uh, congrats to all the present members, and of course, with the blessing and of course under the guidance of our chairman of NIRC, CA Abhinav Agarwal ji, and the whole team member, the regional council member, the secretary Navya Malhotra ji, and of course today's speaker CA Divya Jain ji, and one of the the very youngest, very energetic chairman of Sagrut branch, CA Mahesh Garg ji, and of course all the present member in this webinar. So first of all, I would welcome all the present member in this webinar. So with the efforts of the whole team members, so we are organizing, the different series. So today we have a very technical and very important topic, which can be the very big opportunity for the chartered accountant, whether you are in a practice or you are in an industry. Because in the industry, the chartered accountant, they are managing so many things, at the back end of the company. They are basically working on the protection of data, privacy of data. If I would say, as a practicing chartered accountant, it's a unique area for the chartered accountant. And as we know, a very important and a very new act that is called Data Protection Act 2023. So, of course, we are waiting for the very important information. So, Divya ji is with us. So, definitely she will share all the importance, all the relevant information which will give us the value addition for our profession as well as for the industry. And of course, it will help to protect our data and the privacy also, as mentioned, at the initial stage mentioned by Akash Vashish ji. So that is very important. So yes, Divya ji, we are waiting for your presentation, and definitely we will get so many things, after learning and after your experience which you have in this particular line. So thank you very much once again and joining this platform, Divya ji, and thank you all of you for welcoming this webinar. Over to you, Akash ji. Thank you for the opportunity, Akash bhai.
Thank you, Jagjit sir. Thank you so much. Now I would request our NIRC Secretary, Navya Malhotra ji, to please share his words of wisdom. Navya sir, please.
A very very good evening to all of you. नमस्कार आप और मैं बस इतना ही कहना चाहूंगा जो आज डेटा प्रोटेक्शन पे दिव्या जी बोलेंगी that would be an enlightening session when we realize हम कस्टमरी प्रैक्टिस तो कर ही जा रहे हैं सारे एक लैपटॉप ले लेते हैं और लैपटॉप लेने के बाद चीजों को हम इंस्टॉल कर लेते हैं फिर एकदम से would be the need of the hour what our chairman has decided to put into place, and this topic is actually desired for us today, and it's not only merely desired, but I should say it is a compulsory topic that requires attention for all. I would sincerely thank the chairman and the whole team of NIRC who's working on these topics, and again thankfully to the speaker and the coordinator and moderators. Like to thank the chairman who's taken the lead in these. Thank you, Abhinav.
Thank you, Navya sir. Thank you so much. Now I would request CA Mahesh Garg ji, who is chairman of Sangrur branch. Mahesh ji, please share some few words.
Good afternoon, everyone. I firstly thank CA Abhinav Agrawal ji, Chairman NIRC, and his team, including the likes of Secretary of NIRC, CA Navya Malhotra ji, Vice Chairman Shalini ma'am in absentia, and CASA Chairperson CA Jagjit Singh Jags ji, for inviting me as a coordinator for today's program. सर ये जो टॉपिक है डिजिटल पर्सनल डाटा प्रोटेक्शन एक्ट का, ये आने वाले टाइम में हमें एज ए चार्टर्ड अकाउंटेंट्स और एज ए कंट्री बहुत मेरे हिसाब से इम्पैक्ट करेगा, क्योंकि जैसा कि आप जानते हैं कि जो यूपीआई के आने के बाद डिजिटल पेमेंट्स जो है, रियल टाइम ट्रांजैक्शंस, अराउंड 46% ट्रांजैक्शंस जो रियल टाइम हो रही है ग्लोबली, वो इंडिया में हो रही है। और वही एज ए चार्टर्ड अकाउंटेंट हमारा उससे भी लेना देना है, डिजिटल ट्रांजैक्शन से भी लेना देना है, प्लस हम चार्टर्ड अकाउंटेंट के पास डिजिटल सिग्नेचर्स पड़े होते हैं क्लाइंट्स के, ठीक है ना, वो भी डिजिटल इस सेक्टर में कवर होंगे। तो उसकी क्या हमारे ऊपर इम्प्लीकेशन आ रही है, हमें क्या सेफ गार्ड लेकर चलना है इन चीजों का, तो वो सारी चीजें हमें एज ए चार्टर्ड अकाउंटेंट भी पता होनी चाहिए। और जो हम एज ए यूजर एंगल से देखें तो हम अपना डाटा कोई भी एंड्रॉइड ऐप है या आईओएस पे जो भी ऐप है उसको कंसेंट आई एग्री करके प्रोवाइड करते रहते हैं, तो उसकी मेरे ऊपर क्या इम्प्लीकेशन आ जाती है और उस कंपनी का क्या ऑब्लिगेशन बनती है मेरे उस डाटा को लेकर, तो वो सारे राइट्स हमें एज सिटीजन भी पता होने चाहिए। और आज के टाइम में ये बहुत ही रेलिवेंट टॉपिक है। मैं चेयरमैन एनआईआर से अभिनव जी का बहुत थैंक यू करना चाहूंगा कि उन्होंने इस प्रोग्राम के ऊपर, इस टॉपिक के ऊपर एक प्रोग्राम कराया। और दिव्या मैम जो आज के हमारे गेस्ट स्पीकर है, उनका भी थैंक यू करना चाहूंगा कि उन्होंने इस प्रोग्राम के लिए एग्री। थैंक यू सर।
Thank you, Mahesh ji. Thank you so much. And now I would like to request our young and dynamic chairman, C. Abhinav Agarwal ji, who is working so hard since he has taken the charge of NIRC. Karta of today's HUF, Abhinav ji, please share your word of wisdom, please, sir.
Very thank you. A very good evening to all of you. My secretary Navya Malhotra ji, Nikasa chairman Jagjit ji, my branch chairman from Sangrur Mahesh Garg ji, moderator Akash Vashish ji, eminent speaker Divya Jain ji, all esteemed members who are joining this webinar program on this new topic, Digital Protection Act 2023. I welcome all of you in this webinar series. This series is our Tech Deck series 2. ये हमारा सेकंड सेमिनार है अंडर अवर विजन ऑफ टेक डेक सीरीज, टेक्नोलॉजी रिलेटेड सीरीज। उसमें जिस तरह की से टॉपिक आप देख पा रहे हैं कि 2023 का नया टॉपिक है, उसी तरह हमारे स्पीकर भी न्यू एंड वाइब्रेंट स्पीकर हैं जो हम लेके आए हैं इस टॉपिक के ऊपर। अभी बहुत कम लोग इस टॉपिक पे प्रैक्टिस कर रहे हैं, लेकिन जिस तरह मैं लोगों से मिलता हूँ अभी मुझे ऐसा लग रहा है महेश जी भी इस टॉपिक के बारे में काफी कुछ जानते हैं, और आकाश भाई की तो स्पेशल रिक्वेस्ट थी कि इस टॉपिक पे उन्हें काम करना है। तो ऑलरेडी इस टॉपिक के ऊपर अवेयरनेस बहुत ज्यादा आ चुकी है और एक प्रोफेशनल अपॉर्चुनिटी है। आज आप जिस तरह समझ सकते हैं कि हम हर छोटी से छोटी चीज की इंपॉर्टेंस है, उसी तरह डाटा एक बहुत इंपॉर्टेंट वैल्यूएबल एक्सपेक्ट है। जो आप बिग फोर्स में देखते होंगे वहां पे ऑलरेडी आप एनओसी या आप एग्रीमेंट साइन करवाते हैं कि नॉन डिस्क्लोजर एग्रीमेंट, जिसमें आप कोई भी डाटा किसी का शेयर नहीं कर सकते। लेकिन अभी एक एक्ट के शेप में भी आ गया जिसमें पेनल क्लॉज और डिफरेंट डिफरेंट लिटिगेशंस होंगी कि अगर आप डाटा किसी का भी आप बिना पूछे, और ये एक इस चीज को भी लेके आए जैसे आप कॉल्स अटेंड करते हैं ना कि चार्टर्ड अकाउंटेंट्स का डाटा शेयर हो गया, डिफरेंट डिफरेंट सेक्टर से आपको अननेसेसरी पूरे दिन जितनी मेन कॉल्स नहीं आती उससे ज्यादा डिस्टर्बिंग कॉल्स आती हैं। तो इन सब चीजों को लेकर ही डाटा प्रोटेक्शन एक्ट बनाया गया है। तो मुझे लगता है कि दिव्या जी इसको बहुत ढंग से एलोबरेट कर पाएंगी अमंग्स द मेंबर्स। और इसमें दिव्या जी मेरी रिक्वेस्ट है कि हम एज अ चार्टर्ड अकाउंटेंट्स के लिए हमारे लिए क्या प्रोफेशनल अपॉर्चुनिटीज है, इसको हम कैसे एक हम आपको और चीज बताना चाहूंगा। हमारे जो इस साल के स्पॉन्सर हैं उसमें एक पीडीपी कंपनी है जो प्रॉपरली डाटा प्रोटेक्शन एक्ट के ऊपर ही काम करती है। वो उनके साथ हम एक सेमिनार उनके साथ भी करेंगे जो हमें उनकी कंपनी के साथ हम कैसे डाटा प्रोटेक्शन एक्ट को अपने क्लाइंट्स के ऊपर एक्चुअली में इम्प्लीमेंट कर सकते हैं, और हम चार्टर्ड अकाउंटेंट्स के लिए वो क्या प्रोफेशनल अपॉर्चुनिटीज है उस पर मैं एक सेशन वो भी कराऊंगा। तो आप हमारे साथ कनेक्टेड रहिए। काफी कुछ प्लानिंग्स में है, अगले 1.5-2 महीने के शेड्यूल्स प्रोग्राम आपको हर महीने हम जिस तरीके से अप्रैल के हमने शेयर करे, मई के भी हम आने वाले पूरे मंथ के प्रोग्राम शेयर कर देंगे। हमने 2 महीने से ई जर्नल्स भी निकाल दिए। ई जर्नल में हम सारे अपने प्रोग्राम्स की अपकमिंग और जो ऑलरेडी पास्ट इवेंट्स की डिटेल्स हम शेयर करते हैं। तो आप एनआईआरसी के साथ जितना कनेक्टेड रहेंगे उतना आपको डे टू डे डेली अपडेट्स और डेली नई चीजें मिलती रहेंगी। आप भी कोई अगर हमें सजेशन दे सकते हैं किसी नए टॉपिक के ऊपर जो आप घर बैठ के देखना चाहते हैं, जिसमें एक फिजिकली आपको अटेंड नहीं कर पाते प्रोग्राम, तो हम उस टॉपिक पे भी आपके लिए कराएंगे। तो इन्हीं शब्दों के साथ मैं धन्यवाद करना चाहूंगा और आज आकाश भाई को बोलूंगा, आकाश भाई पूरा एक प्रोग्राम आपने ढंग से मॉडरेट करना है। सारे लोगों के क्वेश्चन आंसर जितने भी एक ऐसा टॉपिक है जिसमें बहुत सारे क्वेश्चन हो सकते हैं लोगों में, तो आप प्लीज उसको अटेंड कीजिएगा और एक आज सबका टाइमली सबको सॉल्यूशन प्रोवाइड कराइएगा। थैंक यू।
Thank you, Abhinav sir. Thank you so much. Now we have our subject matter expert on this topic, Divya Jain. Divya Jain is a chartered accountant with extensive experience in the data protection laws. She is currently working on the subjects like GDPR, General Data Protection Rules in the Europe countries with various overseas clients since last 5 years over the topic of the GDPR implementations. She is currently involved in disseminating the knowledge on the data protection through various platforms like CAG, IIA, and International Center for Information System and Audit. So we can just see she has a vast practical exposure in the field of data protection. Ma'am, we all chartered accountants are eagerly waiting for your deliberation on the overview of the DPDP Act and its especially its implications on the chartered accountants practice and opportunities for CAs. So over to you, Divya ma'am.
Thank you so much, Akash, for the brief introduction. And I thank you, all the other members, Jagjit sir, Mahesh sir, and Abhinav ji, and also Navya also. So basically, this is for the very first time I am deliberating a session on the NIRC platform here. So yes, and I welcome all the participants who have joined this webinar on a very recently enacted law in India, that is Digital Personal Data Protection Act, enacted back in August 2023. So yes, before just starting the webinar, I just want to say that I have divided the webinar into two parts basically. First of all, I will give you the brief or the overview of the provisions of this act, and then after that, I will be explaining the implications of this act on the chartered accountants. Either the chartered accountants are into practice or into jobs. So I'll try to cover as much as aspects that are possible. So yes, and also regarding the queries, we can have two basically parts of queries. Once I'll complete the provisions of the act, we can have a small Q&A session. Then after completing the complete webinar, we can again have a Q&A session, and I will try to resolve all the queries of the participants. So I think let's get started. I'm just sharing my screen. Is my screen visible?
Yes, ma'am. Yes, ma'am. It's visible.
Okay. So yeah, so this is the today's topic. So what is to start the webinar? I just a second. Yeah, to start the webinar, I just want to have a query, or basically want to start from a question itself, that what is the need of Digital Personal Data Protection Act? We were already doing very good. We already have an act in place that talks about the information technology. Like we have a IT Act in place since very long, and that was amended over the time 2-3 times. So what is the basic actual requirement for Digital Personal Data Protection Act? So let me, before giving my opinion about this or tell you what the act says or what the other people says about the need of Digital Personal Data Protection Act, let me take you through a small video. I request you to just have a look, a clear look about how the data moves from one place to another, another place to another place. So this is just a small 1-minute video. I'm just playing it right away. I request you all to have to pay attention on this. So yes, so basically what is the purpose of showing the video to you is that your data matters. So I think from the video, you'll able to identify that how data moves in the digital world, or the world we can say the internet world. डेटा किस तरीके से मूव करता है फ्रॉम वन प्लेस टू अनदर, एंड कैसे एक जगह अगर आप डेटा इंटरनेट पे डाल देते हैं तो वो किस तरीके से जो डेटा है वो डिफरेंट डिफरेंट ऑर्गेनाइजेशंस के पास पहुंच जाता है, और कैसे ही आप डिफरेंट डिफरेंट कॉल्स और मैसेजेस और टारगेट मार्केटिंग रिसीव करना स्टार्ट कर देते हैं. So yes, this is the reason why we need the Digital Personal Data Protection Act, that we have to protect our personal data. We are the owners of the personal data and we need to have the right over it. We need to have a control over it. That's way I can say that we need the Digital Personal Data Protection. This is not the first time in the world that we are going through the journey of digital data privacy rules or regulations. We have already gone through the journey in different other countries like GDPR, CCPA in California, in Brazil, in South Africa. Like a lot of countries have already gone through the journey of for these digital data protection regulations, and now in India we are also being a part of this journey to how that we can protect our personal data. And this is the first reason that we need the Digital Personal Data Protection Act, because we need the control our own data. We are the owners and we need the control. As you already know about the digital footprints, once we put any data over the internet, it becomes the digital footprints. Like जैसे जैसे हम चलते हैं वैसे वैसे फुटप्रिंट्स आगे चलते हैं. सिमिलर वेज में जैसे जैसा डेटा इंटरनेट पे डलता चला जाता है, लाइक वाइज वो डेटा इंटरनेट पे फ्लोट होना स्टार्ट हो जाता है. दैट वी कॉल द डिजिटल फुटप्रिंट्स, एंड वी एज अ इंडिविजुअल डू नॉट हैव कंट्रोल ओवर इट इफ वी डू नॉट हैव अ stringent regulations to control it. So that's why we need the regulation. This is the second point that I can say, that to control the digital footprints and to delete it, if we want to delete the digital footprint, we need to have this regulation in place. Then yes, of course, for enhancing the trust, like if I'm sharing a data with someone and I don't trust that person, then in that case I am not comfortable sharing my data. But yes, if I have a regulation, I have a control, I have a rights, then in that case these rights, obligation and everything is possible because of a regulation in place, and that basically enhance the trust between the organization, data individuals, and the person as a data subjects of India. And yes, as this act, the DPDP Act, provides some rights to the individuals of India or the citizens of India. So basically, that is empowering the Indian citizen to control their own personal data. And if they don't want to share their data with someone, then they have the right to not to share the data. In the previous video that I've shown you, the person do not have a right that do not want, if they don't want to share the data over the internet, they don't have the right. But with this regulation, we'll have the right to share or not to share our data. So this way I can say that we definitely need a stringent regulation, and we are already in the journey of having this regulation in place in India. So the journey was started as already deliberated or said during the introduction as well. The journey was started when the case Puttaswamy judgment came as a landmark judgment that declared the right to privacy as a fundamental right of Indian citizen in the Constitution of India, and the journey started from there. After that, the draft bills of these, like the older versions, or we can say the previous iterations of this act, came into the Lok Sabha, Rajya Sabha, and then went for the joint parliamentary committee for the suggestions. And then in 2022, all the previous acts were discarded, and because of the lot of the lot of the observations from the Joint Parliamentary Committee, the act was discarded that time, the bill was discarded that time, and again we came up with a new act. The current act came into picture on 5th of August 2023, and then finally it was passed by both the houses on 9th of August and signed by the president on 11th August, and finally on 11th August this act was presented in the official Gazette of India. So finally, we can say that we have already begun the journey of digital personal data, or we can say the personal data of individual. And yes, the enforcement or the rules and regulation or the implementation rules and regulation are yet to come. But yes, we can say that we have already initiated or started the journey. To start with the applicability, to whom this act is applicable, as the name suggests that this act is applicable on digital personal. So we have to discuss about the digital and personal both. So this act is applicable on digital personal. So what is personal data? Any data about any individual who is identifiable or in relation to such data. It means that if I am identifiable from my information, that information become a personal information, or we can say that a personal data. Like my email ID. A person can directly reach out to me from my email ID. A person can directly reach out to me from my address. Person can directly reach out to me from my phone number. So these kind of data we call them as a personal data or a personal identifiable information. All across the globe, we call this information personal identifiable information. And if you just have my name, let's say, then my name is not a personal information. But let's say for Shah Rukh Khan, the name can be his personal information. So yes, if a person can be identifiable from a information, that information will be called as a personal identifiable information. Then to whom this act is applicable? To whom this act is applicable means it applicable to all the kind of legal entities we have in India, like private limited companies, private partnership firm, public companies, foreign companies, government entities, even the ministries, the government itself, the states, and any other body corporate we can talk about. So it is applicable to all. I have recently talked with few of the chartered accountants and come with the question all the people were asking, like, why this act will be applicable to chartered accountants. But as of now, I can clearly say based on the act that it is applicable to everyone who is running a business in India, and there is no exception even for the chartered accountants. So, as the law is currently says that there is no exception to anyone or any kind of entity, even if it is a sole proprietorship form. So, let's move ahead with the material scope. Like this act is applicable to digital data, like digital personal. So this act is applicable to personal data that is collected in a digitized format. Like हमने अगर कोई data डिजिटल फॉर्मेट में कलेक्ट किया है तो ये एक्ट एप्लीकेबल होगा. अगर हमने कोई डेटा नॉन डिजिटल फॉर्मेट में कलेक्ट किया है, लाइक वी हैव कलेक्टेड अ केवाईसी डॉक्यूमेंट्स ऑन पेपर फॉर्मेट and we haven't converted it, then this act is not applicable. But once we convert it, like scan the document and save in our folder or files, then this act is applicable. Then the personal data is collected in digitized format, or personal data that is collected in digitized format but subsequently collected in non-digitized format and digitized subsequently. So this act is applicable in both the situations. Then let's talk about the territorial scope. Processing of personal data within the territory of India. If we are processing the data within the territory of India, this act is applicable. What about if we are processing the data outside the territory of India? This act is also applicable on non-territorial situations also. If we are processing the data outside India, this act is applicable. But yes, if we are collecting the data of Indian data subjects to provide some goods or services. So outside India, if activities related to offering goods and services to the principal within the territory of India. So this is basically the extraterritorial scope of this act. Then this act doesn't apply to or not applicable to processing of domestic or personal information for the domestic or personal purposes by individual. Let's say I have shared the information to my friend because I'm going to her wedding or I'm going to some party and my KYC documents are required, and I shared that document for a personal purpose. Now, in that particular case, this act is not applicable. My friend is collecting information, but this act is not applicable. If I'm making my information public myself, like I'm putting some information like on LinkedIn or putting my email ID, my phone number, if my information is already public and I am the one who made that information publicly available, then that act is not applicable. Then research, archiving, and statistics. If an organization is conducting some research activities or statistics, like government is conducting research activities or conducting some statistical information, like conducting some statistics to perform some index, to collect the data, to do some index information. So in that particular case, this act is not applicable. But as of now, this research and archiving statistics are not applicable category. But if we do the commercial research, like if let's say a CA or a lot of CA firms or let's say business consulting firms are already involved in conducting the market research. So what we say about market research or a commercial research, will those research are also out of the scope? So as of now, there is no clarity on this point. But yes, if as it is mentioned as clearly research and archiving and statistics, so from this point we can say that commercial research are as of now out of the preview of this act. Then state instrumentalities, like the state government, the ministry, if they are using the data like the personal data for the purpose of sovereignty and integrity of India, then in that particular case, the act is not applicable. So from the applicability, I think you will be able to understand the vast implication of this act on all the persons, all the entities who are conducting the business in India. They have to comply with the act. After exploring its scope, do you foresee the DPDP Act reaching out to include chartered accountants? Yes, there is a big yes that this act will be applicable to chartered accountants. So yeah, about the timeline, this act is already enacted, but yes, the implementation rules, as it is clearly mentioned in the act, that the implementation rules will come and central government will publish the implementation rules. So we are expecting the implementation rules to come soon. At the time of the enactment of the act, like in August 2023, we were expecting that the implementation will take approximately 9 months to come. But as everybody know that this is the election period going on, so we are expecting more 6-7 months, or let's say 9 months to implementation rules to be published by the central government. And for the update, I have recently heard in an interview that once the government will be in place, then they will be announcing the implementation rules in the first like the initial 100 days, or they will talk about this. So this is a very important topic for them. So yes. So yeah, let's talk about the key stakeholders. Who are the key stakeholders? Stakeholders कौन होते हैं? Basically, I think everybody know because we are here with all the chartered accountants. So stakeholders are the ones who are directly or indirectly impacted or involved in this Digital Personal Data Protection Act. First of all, we have data principals. Data principals are like you and me, whose data is being collected, like individuals basically, whose data is being collected, used, and processed by the data fiduciaries. So if you and me are the data principals, then our data will be used, collected, and even our children's data is also collected. And though children's, disabled person, and every person is a data principal. And let's talk about the business. We already have a business information in our place. So do the business also being to be a data principal? No. Only the individual will be considered as a data principal. And if we have any specific information that directly relates to a business entity and identifiable to business entity, in that case, the business is not a data principal. Individual principal, data principal is a individual. Then who is a data fiduciary? Data fiduciaries are all the organizations who are collecting the data, processing the data, or even determining the purpose or means of processing the data. Means all the firms, all the organizations who are collecting the data, processing the data. Then who is the data processor? If data processor is someone who on the behalf of data fiduciaries process the data. Do you think of any data processor? Like CA firms do share the data for processing to any other organization? Yes, they do, because we are saving our data or securing our data on some servers, on some platforms. Then even saving or retention is also considered as processing. So in that case, we can say that data processors are the one who are saving the data on behalf of our organizations. Saving is not the only processing activity. I will take the processing, what we call the processing, in the next slide. But yes, the data processors are the one who are doing or processing the data on behalf of data fiduciaries. Who is the concerned manager? This is very new here in our act. If we compare this with in regard to the global regulations, concerned manager was not a terminology and even not a stakeholder in other regulations. Concerned manager is someone who will manage the concern of on behalf of the data fiduciaries. I will discuss the concerned manager in a bit in more detail, but for now, I just want to say that a person who will be managing the concerned or act as a bridge between the data principals and the data fiduciary will be considered as a concerned manager. Then yes, as I've discussed, that Digital Personal Data Protection Act will be applicable on personal data, will be applicable on digital data, and but this act will be applicable only when the processing is done. If we are collecting the data, not processing, then this act is not applicable. But if we are storing the data, this act is applicable. So what do you mean by processing? So this act give a detailed definition of processing. If processing means collecting, recording, organizing, structuring, storage, adaptation, retrieval, use, alignment, combination, indexing, sharing, disclosure by transmission, dismission, or otherwise making available, restriction, erasure, destruction. So I think this processing covers everything. If we are collecting the data, not doing anything, saving in our software, saving in our laptop, then also this is covered under the definition of processing. And yes, processing in relation to personal data. If we are collecting a business information and saving in our laptop, that is not the act with that information. On that information, this act is not applicable. This act is applicable on personal data. Means a wholly or partly automated operations. Like we have to conduct either some partly or wholly automated operations or perform certain set of operations on the digital personal data, then only after that this act will be applicable. So इस act को applicable करने के लिए क्या-क्या चाहिए? हमें personal data चाहिए, digital format में चाहिए और उस पे processing होनी चाहिए. ये तीनों चीजें होंगी तभी हम बोल सकते हैं कि ये act यानी कि DPDP Act applicable हो जाएगा. Then yes, let's talk about the grounds of processing. As I've mentioned that we have to process the data. We can process the data in two ways. First way, that is a concerned, that I'll take a concerned and process the data. And the other way is legitimate use. So let's take one by one. First of all, I'll explain about the concerned part. So what is concerned? Whenever I have to process the data as a data fiduciary, then I have to obtain a consent from the data individual. Let's say I am collecting a KYC from a client to process the data, even for storage, let's say I'm using that data for the ITR purpose, or I'm using that data, I'm sharing that data with, let's say, other party software. So for that, all the processing, I have to obtain consent from the particular data principal. Data principal may give the consent, manage the consent, review the consent, or withdraw their consent. And yes, this consent will be done with the help of consent manager. So the data principal will do all the things like giving the consent, manage, review, and withdraw or withdraw their consent with the help of consent manager. So again here, the consent manager become a very important or a key person or a bridge between the data principals and the data fiduciary. And whenever we have to obtain a consent, we have to give a privacy notice to the data principal. What is privacy notice? So this is privacy notice. Privacy notice is basically a notice that is to be given to the data principals about what personal data we are collecting, what processes or purposes for which we are collecting the data, how the data individual or data principal have a right to withdraw the consent, how the data principal have a right or how to exercise the right of grievance redressal and manner of complaining to the board. So these are just the few pointers that we have collected from the different sections of this act, that this information needs to be clearly mentioned in the notice that needs to be given before the consent is taken or along with the consent, like privacy notice to accompany or preceded the consent request. We cannot give the privacy notice after the consent is already been taken. And one more point, and a very interesting point, I can say that option to access privacy notice in English or language listed in 18th schedule to Indian Constitution. So I think you already know that we have 22 languages listed in 8th schedule to Indian Constitution. Oh my God. So actually the point here is we have to give the privacy notice in 22 languages. And there is no exception to that. This is a very obligation on the data fiduciaries that they have to give the privacy notice in 22 languages. Fair enough. So let's talk about the consent request. We have to give the privacy notice and we have to obtain the consent. So what is consent request? Consent request is to be obtained from data principal and it should be specific. Like it should be specific कि हम किस पर्पस के लिए डेटा को यूज करने वाले हैं. आज मैंने consent request आपसे ली है to use the data for ITR purpose, or let's say for DSC digital signatures purpose. So अब इस कंसर्न जिस पर्पस के लिए मैंने ली है मैं उसी के लिए डेटा यूज कर सकती हूँ, एंड जैसे ही वो कंसर्न कंप्लीट हो जाएगी मुझे वो डेटा डिलीट कर देना पड़ेगा. सो दैट इज व्हाई द कंसर्न रिक्वेस्ट नीड टू बी स्पेसिफिक. If I have to use it, let's say for marketing purpose, or I have to use it for, let's say, for sending the newsletter, then we have to mention that in the consent that consent is asked from the data individual that we have to send the newsletters to you. It should be informed, clearly mentioned, unconditional, unambiguous, clear affirmative action, and limited for specific purpose. So yes, we have to take the consent from the data principals. Then option to withdraw the consent. Yes, we have to give the data principal an option to withdraw our consent. Like I am giving a consent, let's say for 3 purposes, which includes the marketing or a newsletter as a purpose. And right after, let's say 3 months, I don't find the newsletter to be relevant. I want to withdraw my consent. So the option to withdraw the consent needs to be given. And it should be as easy as to give the consent. मतलब ऐसा नहीं होना चाहिए कि कंसर्न देना तो बहुत आसान हो और कंसर्न विड्रॉ करने के लिए मुझे 4 दिन का प्रोसेस फॉलो करना हो, मुझे ईमेल करना हो, मुझे ईमेल आईडी ढूंढनी पड़े, आई हैव टू राइट एंड then reply to the emails. It should not be like that. It should be as easy as to give the consent. Then option to access the consent request in English or any language specified under the 8th schedule to Indian Constitution, which means that just like the privacy notice, हमें consent request भी 22 languages में लेनी है. If someone wants sitting in Tamil Nadu and you are performing some activities on behalf of that person and you are collecting some data and that person wants that consent to be given in their native language, then you have the obligation to give that consent or privacy notice in that native language. Then after that, in the consent request, we have to give the details of the authorized person who will be responsible for handling the consent. And who is the person who's handling the consent? Is the consent manager. So we have to have, every data fiduciary will have to have a mandatory consent manager. So every data fiduciary, all the chartered accountants who are running their organizations are the data fiduciaries. So they'll have to have a consent manager in place, and they have to have that consent manager email ID and phone numbers or the contact details mentioned in the consent request as well as the privacy notice, so that people like their clients, individual, if they want to withdraw the consent, review, manage, or want to discuss anything regarding this act or data privacy or their data shared by them, then they can reach out to the consent manager directly. Consent to be managed through an accessible, transparent, or interoperable platform. Consent should be managed in a transparent manner. Like if I want to withdraw my consent, it should be transparently shown to me that your consent is withdrawn and the data is not processed anymore for the purpose for which the consent is withdrawn. It should not be like hidden or an ambiguity involved in that particular process of consent management. It should be transparent for the data fiduciary as well as for the data individuals. And one more important thing is that consent manager needs to be registered with Data Protection Board of India. We will discuss about Data Protection Board of India in detail in a while, but yes, Data Protection Board of India is it's a board that needs to be that will be established under this act, and every consent manager have to register themselves. As of now, there is no qualification or a minimum requirement to be mentioned regarding the consent manager's eligibility. So anybody can be a consent manager, or later on, I think in the implementation rules, we will see like who will be the consent manager, or central government can prescribe certain qualification regarding that. So yes, from this slide, we have discussed or covered the consent part. Now let's come to the legitimate use part. So for all the type of processing, we have discussed that there are lot of type of processing. One way of processing is to obtain consent, but there are certain other purposes for which consent is not required. So what are those purposes? Those purposes we call legitimate use. And even if the consent is not required, we are not supposed to give the privacy notice in this kind of processing. So what are basically the legitimate uses, or we can call them a legal basis for processing the personal data without the consent or the privacy notice. So there are a few of the pointers mentioned in the Act itself for specified purpose for which data principal has voluntarily provided her personal data to data fiduciary. Like if someone comes to you and asks them to file their income tax return, and they voluntarily provide you all the information and doesn't mention or doesn't indicate it that do not use my information without my consent for any purposes other than filing the ITR, then in that case, the consent is not required, and voluntarily providing if someone is voluntarily providing the data, then consent is not required. But yes, if the data is voluntarily provided and the person mentioned that do not use this data for any other purpose, then yes, you are not supposed to use that data for any other purpose. For employment, yes, if we are employing or hiring someone, we are collecting their personal information like their email ID, their qualification details, their phone number, and a lot of personal information we collect. So this is also a legitimate purpose, and we are not supposed to take a consent from the prospective employee or from the employee. Like if we are at the time of interview collecting the data during the employment, or even after the post-employment, if we are collecting any data for the purpose of employment, consent is not required. And for safeguarding the employer from the loss of liability, such as prevention from corporate espionage, maintenance of confidentiality of trade secrets, intellectual property, classified information, or such kind of frauds, if we want to safeguard the employer, and for that safeguarding purpose, processing of personal data of employee is necessary, then in that case, consent is not required. Responding to a medical emergency. Let's say we have an employee in our office, or let's say we have any guest in our office, and in that particular case, they suffering from medical emergency. So we'll not wait for the concerned to use their personal information to be shared with the doctors. If we have any personal information that can help to for the medical emergency in a life or a death situation or any critical situation, then in that particular case, the consent is not required. For compliance with any judgment or order issued under law or fulfilling obligations under the law. Yes, if there is a court order or a judgment passed and we have to share some personal data, then in that case, consent is not required. This is allowed as per the law to share that personal information for that judgment or order to be completed of fulfilling our obligation under the law. So, yes, now as we are discussing about the data fiduciaries, so I think I give you a fair idea about how we can process the data, either through consent or through legitimate use. If anything comes under the legitimate use, chartered accountants who are running the practice are not supposed to take consent, otherwise they have to take the consent. Now, what are the obligations of data fiduciaries? We are saying that data fiduciaries have to do this, to have to do that. Yes, the whole act putting all the obligation on the data fiduciaries. Data fiduciaries are the person, let me remind you again, data fiduciaries are the person who are collecting the data or defining the means of processing or collecting the data. All the C firms are collecting the data are the data fiduciaries. So what are the obligations? Compliance with the act. So yes, they have to comply with the act. There is no exception to the compliance of this act. Then what are the other obligations? Obligations relating to third parties and data processors. As we have mentioned that data fiduciaries are sharing different kind of data with data processors for various purposes, like for retention, for processing, for conducting certain work on behalf of the data fiduciary. Then in that case, the obligation of data fiduciary is to have a valid contract with the data processor. What is a valid contract? This is not explained in the act that what constitutes a valid contract. Valid contract can be defined in other acts which are available here in India, but DPDP Act doesn't define anything called valid contract. As I've obtained or referred the GDPR, the General Data Protection Regulation in Europe, they are not even explaining the valid contract, but there are certain things that they want to include in the valid contract. First is to have an obligation to audit the data processor. Data fiduciary should have a option to audit the data processor's data to understand the standard operating procedures. They have to have a clause wherein it is clearly mentioned the data processor will not use the data for any purposes other than defined by the data fiduciaries. Or yes, the most importantly, the indemnity clause. Like if the data processor, let's say, accidentally or intentionally share the data with someone, then who will be the one who's liable? Because if the data fiduciary do such data breaches, then the data fiduciaries are the one who are liable. But if data processor do such breaches, who are the one who are liable? The data fiduciaries are the liable as per the act, and we have to have a valid contract with the data processor so that we can recover in case anything happens like that. So yes, this valid contract can be referred from different clauses or case to case basis, but yes, few clauses that I've mentioned can have in the valid contract. Use correct basis for data processing. Yes, just the purpose for which we are processing the data, the purpose for which we have obtained the consent, we have to process the data for that particular purpose only. This is an obligation of data fiduciary. Provide a clear, concise, or a comprehensible notice to data principals that we have discussed, that we have to provide a clear, concise, and a comprehensible notice to data principal. And yes, in case we are processing the data of children, then in that case, we'll need to have a verifiable parental consent. This we'll discuss in detail in the next 2-3 slides. Personal data to be complete, accurate, and consistent. This is very important, that being a data fiduciary, if we are processing a data of an individual, then we have to keep that data complete, accurate, and consistent. It means that if I'm collecting a data, being a chartered accountant, for any purpose, and if anything change happen to that particular person's, let's say, name, address, then it is my responsibility to keep that data updated, specifically to two purposes. If I'm sharing that data with any other data fiduciary, and if any decision is to be taken regarding the data principle on the basis of the information that I'm sharing, then in that case, I have to make sure that data needs to be complete, accurate, and consistent. Then I have to delete and erase the data as soon as the purpose is accomplished. But I think we already have an obligation to save the data or to secure the data for a certain period of time under the different statutes. In this case, what I can say here is, if there is an obligation to save the data, then that act will prevail. But once the obligation is completed, we have to delete the data. Here, the act clearly mentions that we have to delete the data as a data fiduciary once the obligation is completed. Like I have collected the data, let's say for the DSC purpose. Then once the DSC are created or prepared, then in that case we have to delete the data. If we have collected the data, let's say bank statement for some filing purpose, then we have to delete the data once the filing is done. And also, the data principal can withdraw the consent. Yes, we have clearly seen that data principal have a right to withdraw the consent. If the data principal withdraws the consent, then we have to delete the data as soon as possible, as soon as we have received the request from the data principal. If we have an obligation, then we can say, but if we do not have an obligation, then we have to delete the data. I think you can clearly see from this point that deletion and erasure of data, we have to have an infrastructure in place, because as on today what I've seen is कि हमें ये पता ही नहीं होता है कि हमारा डेटा कहाँ कहाँ पे है, कितना डेटा हमारे पास रखा हुआ है और कितना पुराना डेटा हमारे पास रखा हुआ है. तो we have to have an infrastructure in place to delete the data. Because अगर infrastructure ही नहीं होगा तो it's not possible for us to delete it. One more point here in the deletion and eraser is, being a data fiduciaries, we are taking the consent, we are processing the data, and if we are sharing the data with the data processor, then it is an obligation of data fiduciary to get the data deleted from all the data processors. So if I'm sharing the data with data processor and my purpose is completed, then I have to get the data deleted from data processor. Also, if my consent is withdrawn, then I also have to get the data deleted from the data processor, and it is the obligation of data fiduciary. Report of personal data breaches to Data Protection Board and data principals. Yes, we have as a data fiduciary, अगर हमने कोई ब्रीच कर दिया है तो यस हमें वो ब्रीच जो है वो डेटा प्रिंसिपल्स को और डेटा प्रोटेक्शन बोर्ड को रिपोर्ट करना है. कितने दिनों में? As of now, it is not mentioned anywhere कि हमें कितने टाइम में उसको रिपोर्ट करना है, but yes, we have to report it as soon as possible because it's not mentioned. But if we see the GDPR or the other regulation, there is a timeline of 72 hours, 60 hours. So might be once the implementation rules will be in place, we'll also see such kind of time limit to report the breaches. Then we as a data fiduciary have to make a reasonable security safeguards to prevent the personal data breaches. This is very important because maximum amount of penalty is implied or can be attracted if this provision is not complied with very seriously. Like we have to have a reasonable security safeguards. Like we have to have we cannot say what security safeguard, but having an antivirus, having a paid software, or having a secured network, these kind of security safeguards, case to case basis, we have to have in place to secure the personal data breaches. Let me give you an example here. This is a established case law in GDPR, wherein a person is sharing a data over an email to one of the client. That data contains the payroll of 20 employees, and that contains all the personal details like email ID, and their tax residency numbers and other personal detail or of the individual, of 20 individual. And the employee of data fiduciary was sharing the data with the client. Later on, it was established that from last 9 months that employee was ceasing, like sending the email and copying it to someone who is not a part of that organization mistakenly. Like मैंने email भेजा and email में ultimately किसी color person को CC में रख दिया. अब now that amounts to a mistake or a breach. As per the GDPR, that was a breach. Even though that was a mistake, but yes, personal information of an individual was shared mistakenly, but that amounts to a breach. And in that breach, we do not have a security safeguard. So yes, the penalty was attracted, and yes, we have to report that kind of breaches with the data principals as well as the data protection board. So these kind of, here we are not talking just about the cyber attacks or the threats or the phishing or these kind of cyber threats. Then we're talking about all the kind of breaches wherein we share the personal data either intentionally or unintentionally. Then the other obligation is to implement technical and organizational measures to ensure effective adherence with the Act. Yes, we have to have technical and organizational measures, like we have to have a policies, standard operating procedures in place to keep the data secure. We have to have a training modules for the employee to keep them aware about these regulations so that this act will be completely implemented in our organization. Then public of business contact information to answer question. This I think we have discussed in the earlier slide as well, like along with the consent request, we have to give a contact information of a person. He can be a concerned manager, and if we want to give a information of person other than concerned manager also, we can give that, but we have to give a business contact information to answer the question. And last but not the least, that we have to give a grievance redressal mechanism to the data principals. If they have any grievance, they'll reach out to you. But how? We have to give them a grievance redressal mechanism, and these are all the obligation of data fiduciaries. What are the obligation of data processor? In our Act, in our DPDP Act, there is no obligation of data processor. Like data processors की कोई obligation नहीं है, इसीलिए we are talking about more and more about valid contract, because we can abide the data processor based on the valid contract only. If we do not have that valid contract, then the data processors can process the data for any purpose, for any reason, without, because they do not have the obligation to take the consent, they do not have the obligation, so ultimately they do not have the penalties also. If we compare this with the GDPR or the other regulations, they are explaining specific obligation for data processors, but our Act is not explaining any or providing any specific obligation for data processors. Then we have another terminology, just a second. Then we have a terminology, significant data fiduciary. What is significant data fiduciary? We have data fiduciary, then we have a categorization, which is called significant data fiduciary. Significant means who are significantly important, who are collecting the volume or sensitivity, who are collecting the volume of data, who are collecting the sensitive personal information, who are giving a risk to the right of data principle, who can give risk to the electoral democracy. Then in that case, that particular entity will become a significant data fiduciary. As of now, there is no significant data fiduciaries defined, and even the parameters that I'm explaining is just mentioned in the Act, but later on the stage, significant data fiduciaries may be classified by the central government based on these parameters, and parameters can be increased, or any one of the parameters can be used to define any data fiduciary be significant data fiduciary. तो कौन हो सकते हैं significant data fiduciaries? Basically any person, any entities who are collecting large volume of data, let's say e-commerce platform, social media platforms, or the hospitals, because they are collecting our very sensitive information like our health data, or we can say that banks, because they are also collecting very important information for the data principles. So they can be any one depending upon these factors decided by the central government. तो significant data fiduciaries को करना क्या है? Significant data fiduciaries को ये सारी obligations पूरे करने हैं जो हमने already discuss किए हैं, and apart from that they already have other obligations. Okay. So what are the other obligations? Other obligations are to appoint a data protection officer. This is not the concerned manager. This is like another officer, that is a data protection officer, that to be based in India. So this is again, a very important thing that a significant data fiduciary have to appoint a DPO that to be based in India. Then they have to appoint an independent auditor for evaluating the compliances. That is another obligation for the data fiduciaries, significant data fiduciaries. Then there is another obligation to conduct a data protection impact assessment. What is data protection impact assessments? I think chartered accountants have a bit of idea about it, because जो भी audits हम करते हैं, we have to conduct the impact assessment. During the internal audit, these terminologies are widely used, like doing the impact assessment of various risk and risk-based audits. So this is more or less, we can say that risk-based internal audit, that is data protection impact assessment, and periodic audit. So periodicity is not mentioned as of now, but yes, the significant data fiduciary have to conduct periodical audits and data protection impact assessment, because they are collecting large volume of data. Their data can be like a risk or risk to the right of data principle, or might be they are collecting the sensitive information. Then yes, comes to the children's data. Just like significant data fiduciary have some additional obligation, if any data fiduciary is collecting the data of a children, then they also have an additional obligation. What is the data of children? Yeah, who is the child? Who is the child? Who is the children basically? Any individual who has not completed the age of 18 years will be a children. 18 years. Okay, but if we compare this age, like age of 18 years with other regulations, this is on the higher end. But yes, this is in synchronization of other regulation, parallel regulations in India. But in GDPR, this age is 16 years, can be reduced to 13 years. But fair enough, we have 18 years of age. So what we have to do additionally in case of children's data fiduciary have to obtain verifiable parental consent for child. Okay, what do you mean by verifiable consent? So data fiduciary have to verify that parental consent is there whenever children's data is processed. And even if you are processing the data of a person with disability, in that case also verifiable guardian's consent is required. So this is the additional obligation. So if we are processing the data of a children, or being a chartered accountant, we are processing the data of children's or person with disability, we have to obtain a parental consent. No processing of personal data that is likely to cause detrimental or well-being of a child. If any processing is creating like a impact or detrimental or well-being of the child, then that processing is restricted. Also, if data fiduciaries are not allowed to use the children's data for targeting monitoring. Like we cannot do target monitoring, target advertising to the children's, like marketing that is directly targeting to the children. So we cannot process the data for behavioral monitoring. We can say we cannot process the children's data for that purpose. And prohibition on exempted. Yes, there is an exemption. Like central government, if later on the later in the time, if they feel like if the data fiduciaries is collecting the data of children, properly safeguarding the data of the children, then they can reduce the age for that particular data fiduciary from, let's say, 18 years to 16 years, or maybe lesser. But yes, that depends upon case-to-case basis, and central government will have the authority to take the decision. What are the rights and obligation of data principals? Just like data fiduciary have the obligation, data principal have the right. Data principal have a right to access the information. If you are collecting the data from any individual, they have a right to access the information. They can ask you any information relating to them. They can ask you how you have processed their data. They can ask you what processing was done, and you have the obligation to prove that this processing or processing is done. Then the other right is data principal have a right to correction and erasure. If being a data individual, I want to correct my information. Let's say my name is changed. I want you to correct my name. So I have a right to get my name corrected. And if I want my details to be erased from your system, I also have a right for the eraser. Then right to nominate. This is a very different or a unique right, which is not seen in any other regulations, that individuals in India can nominate any other individual to exercise the right in the case of their death or incapacity. Like if let's say after my death, any person or my nominee have a right to decide about my personal data, what is to be done about my personal data. So I can nominate a person for that. Right to grievance redressal. Individual have the right to readily available means of registering grievance with the data fiduciary. That we are discussing like since the beginning, that we have the data fiduciary have to give a grievance redressal to the data fiduciary, to the data principals. Then right to withdraw consent. This we have already discussed that data principal have been empowered with the right to cease processing by withdrawing the consent. And wherever consent is not required, then in that case, right to access or right to correction and erasure is not possible. If I'm not obtained, I'm, let's say, as a data fiduciary, not taking any consent, that I'm not have an obligation. I don't have an obligation to give you the right to access information, correction of information, or erasure of information. Then as a data principal, I also have an obligation not to register a false or a frivolous complaint, and do not interpersonate regarding any other person. Like मुझे किसी को कोई गलत कंप्लेन किसी के बिहाफ पे रजिस्टर नहीं करना एज अ डेटा प्रिंसिपल, एंड ऑल्सो किसी और को रिप्रेजेंट नहीं करना है, interpersonate, like I'm not acting on behalf of someone. मुझे ये दोनों चीजें नहीं करनी है as a data principles. Just like give you an example, मुझे अपनी information correct करानी है and मैं अपनी इंफॉर्मेशन खुद करेक्ट करा रही हूँ, बट मैं किसी और की इंफॉर्मेशन करेक्ट कराने के लिए अगर रिक्वेस्ट भेज देती हूँ, एट दैट पॉइंट ऑफ टाइम आई एम इंटरपर्सनेटिंग ऑन बिहाफ ऑफ दैट पर्सन, एंड आई एम नॉट सपोज टू डू एज पर दिस I am not supposed to do this as per this act. So yes, there is a penalty also attached to it. If I'm doing anything like that, I'm doing any not completing my obligations appropriately, then there is a penalty of ₹10,000 to the data principals. Then let's talk about the cross-border transfer of data. So as of now, if we see in the previous act, like a IT Act, which is taking care of this kind of cross-border transaction before this act was in place. So there is certain layer of restrictions while we are transferring data outside India, but DPDP Act clearly mentioned that there is no restriction on sending the data outside India, except the restricted countries. So basically, there will be a negative list. All the countries which will be considered to be notified by the central government under the negative list. In that particular countries, we are not from India, we are not able to share the data with those countries. But as of now, there is no such notification in place. So there is no negative list currently. But if we compare this act with the previous iterations of this act, like the previous bills which were in place, those acts have a layer of restrictions whenever we have to share the data outside India. But here, this act aims to be very simpler. We can say that only negative list will be in place in the later stage. Otherwise, we are allowed to share the data. And I think this is very important for the startups also, because startups economy is like helping the Indian government, or is helping the startups, and also the startups are very much like very situation, like helping the economy to grow, to be honest. So in that particular scenario, if we are there using the server or the software from the different organizations, they have to share the data to those countries. If we put a blanket restriction to not to use the not to share the data or not to transfer the data to different countries, in that particular case, that that will be against the ease of doing business. So in that's the, I think, the basis behind keeping this as a negative list format for cross-border transfer of data. Then as we have discussed more or less the complete act, then we have certain exemptions wherein the whole act will not be exempted, but few sections will be exempted, like few will be remain applicable, even the exemption will be in place. So let me give you the idea of which sections will be exempted if this exemption will be applicable. So basically, for processing the personal data, the concern will not become a problem. That whenever we are processing the data, then in these particular exemption cases, we are not supposed to take the consent. And we are not supposed to complete the obligation of erasures and retentions. So what are these exemptions? Basically, for enforcing any legal right or claim, I think this is clear from the wordings itself, that to claim any legal right and for any legal right or claim, data can be processed without the consent. For performance of any judicial, regulatory, or supervisory function by a judicial authority, I think this is also clear. In the interest of prevention, detection, investigation, or prosecution of an offense or contravention of any law, then in that case, if we have to share some personal data for the prevention or detection of any offense or a contravention of any law, then in that case, the consent is not required. Then very interesting point is processing of personal data of data principal outside India pursuant to any contract entered into within a foreign party. So what is this basically? Let's say we are a data fiduciary based in India and have a contract with a party sitting outside India. And we are collecting a data of data individuals, Indian data individual based outside India, or any other individual. Data individual might be Indian or maybe foreign data subject. Then in that particular case, this act is not applicable. What is the actual example of this point is the outsourcing business. We are in India, we are managing the outsourcing business like back office in India, and this act exempt those industry and those back office and the outsourcing industry from the DPDP Act implications. Because ultimately, if we are processing data in India, this act must have to be applied, but what we are doing is collecting the data of foreign data individuals, not in the territory of India. So might be the idea behind the exemption is that because we are collecting the data of, let's say, European citizens or maybe a citizen of America, then because we are collecting their citizens' data, then we might be complying with the other regulations, and to ease the business here in India, and also to see that already they are complying with other regulations, this exemption was here in place. And yes, the other point is we are not required any consent if it is necessary for processing of personal data for a scheme of compromise or arrangement or merger amalgamation of two or more companies, if the court or tribunal have already approved it. Then in that case, if we have to process certain personal data, then consent is not required. Ascertaining the whereabouts, financial information, assets and liability of any person from whom a claim is due against a debt. So if any claim is due, like a financial institutions are facing some problems in claiming a due from a particular person, and then in that particular case, they can use the personal information, ascertain their assets and liabilities to process or to perform any recovery, then in that particular case, the concern is not required. Then there are certain other exemptions related to government, like government have certain exemptions like for sovereignty, for integrity, for national threats, for public order, they can use the data without the consent. Then in case of exemption to startups, yes, there can be certain exemptions that can be given to startup from certain provisions, but as of now, that was not decided yet, and central government will later on the stage will define which exemptions can be given from which provisions, and also the startup is not yet defined. Startups are just mentioned as a private limited company or a partnership firm, but who are the eligible startups? It's not yet mentioned anywhere in the act. And there can be other exemptions depend upon central government if they want to give exemptions from certain regulations for a certain time period of time to certain industries that central government can decide, but it means that central government have a power to decide on the exemptions. Then what is the oversight mechanism? As we have a there will be a grievance redressal. If any data principal have a grievance, they'll reach to data protection board. Then they'll reach if the data protection board will not give an appropriate resolution, then they can reach to TDSAT. That is a telecom dispute settlement appellate tribunal, and if they are not able to get a proper resolution, then they can reach to the solution as well. If the appellate tribunal and data protection board find it necessary to have a mediation to be done between the parties for the resolution, then that mechanism can also be decided, and option is here in this act. Then the voluntary undertaking. Voluntary undertaking is something like if a data fiduciary is in any of the breach or any of the case that is pending before the data protection board, then data fiduciaries can ask them that they will complete the obligation, and if they'll give the voluntary obligation that they will complete all the obligation or they'll not do certain things, then in that particular case, all the cases will remain as it is and the voluntary undertaking will prevail. And the data protection board will oversee if the data fiduciary is completing the obligation or not. If the obligation were not completed, even after giving the voluntary obligation, data protection board will take the necessary actions and putting the penalties if required. Then these are the penalties. Yes, of course. As you have seen that the penalties are going up to 250 crores. This is the maximum penalties, and the penalties are very stringent. And I think to secure our personal data, to have a stringent penalty, it is very, very necessary to have a stringent penalty in place. So as well as there is no capping, like 2 or 3 penalties can merge together if the breach happens and security safeguards are not in place. So if security safeguards are not in place, then the penalty is up to 250 crores. If the significant data fiduciaries are not able to complete the obligation, then the penalties are 150 crores. And if the breach notifications are not given, then the penalty is 200 crores. And if the children's data are not the obligation related to children data are not completed, then also the penalty is 200 crores. And for any residual breach or any residual non-compliance, the penalty is minimum 50 crores. And yes, as we have already discussed, then on data principal, the penalty is ₹10,000 if the data principal did not complete their obligation. So here we comes to an end to the provisions of this act. So let me iterate what we have discussed, that this act covers only the personal data. only the digital personal data, no non-personal data coverage, no categorization of data into sensitive data, critical data. There is a flat personal data. Transfer of personal data allowed to all other jurisdiction, only the negative list provision is there. No specific obligation on data processors, and even no materiality or risk for notifying the personal data breaches. Obligation on data processors to notify the data breaches was there in the previous iteration of the Act, but it is not here in the current Act. So I think this comes to an end of the provisions of the personal data, digital personal data regulation. So if you want to have the, I request if anybody have any query, or if the panel wants to have a query in between, or we'll just continue with the case study and take the queries at the end of the session.
We have some queries, ma'am. Let's take first those queries.
Sure, no problem.
So, Samtaji is asking, like, can you give some example about who are the data processors? Can you name some examples?
Yeah. So if we talk about, let's say, a CA firm, so who can be a data processor for the CA firms are, like, if we are using the servers, let's say Amazon server, Dropbox, Google Drive, and if we are outsourcing our work to someone else, then that particular party or affiliate become the data processor. And if we are using the softwares like Tele, if we are using the softwares like Zoho, if we are using the softwares like WebTel, Computex, different softwares or different, we are taking the help of other person or other party or enterprise to complete ERP, SAP. So all these become our data processor because we are using their service and they are processing our data on our behalf.
Another query is, ma'am,
I think
Ahuja is asking, like, it says only English or language stated in the Indian Constitution. So shouldn't it be sufficient to take consent in English language only?
Sorry, your voice is breaking. Can you please repeat the question again?
Ma'am, the question is that Act says English or language stated in the Constitution for taking the consent. So it will be sufficient to take consent in English language only rather than in the institute of 22 languages.
No, the Act clearly specifies that the party or the data individual have the option. हमें उस person को option देना है कि उसे किस language में पढ़ना है. अब उस person को option देने का मतलब languages में अपनी consent को और privacy notice को open रखना है. Like अगर मुझे आपको let's say option देना है, तो अब आपको ऑप्शन में कैसे दूंगी? अगर मैंने इंग्लिश में ही पब्लिश किया है तो आपके पास वो ऑप्शन कैसे आएगा? आपके पास वो ऑप्शन तभी आएगा जब आपके पास वहां पे ऑप्शन अवेलेबल होगा टू चेंज द लैंग्वेज फ्रॉम इंग्लिश टू लेट्स से तमिल और अदर लैंग्वेजेस नोटिफाइड. सो इट इज नॉट लाइक कि हमें सिर्फ इंग्लिश में देना है. द एक्ट इज वेरी क्लियर दैट हमें 22 लैंग्वेजेस का ऑप्शन देना है.
Deepak ji is asking, ma'am, whether it is applicable on telecommunication or electricity distribution companies which sends bills. If yes, then how they can implement the same, as they have to mention the customer's name, mobile number on their invoices and all.
Yes, this is applicable. Whosoever is collecting the personal information, as I have mentioned that the banks are collecting, the healthcare industry, the hospitals are collecting personal information. So just like same, the insurance companies, the electricity companies, whosoever is collecting the personal information have to implement this act. So the implementation can vary. Like for a smaller organization, it can be a simpler or easy process, but for a larger organization, it can be a complicated or a bigger or a larger process. But yes, they have to comply with us.
Sanjeev ji is asking, like, what will be the constitution of the Data Protection Board? Like, who will be the participant in the Data Protection Board?
The data protection board will be established and there will be members in the data protection board. There will be a member from the central government, there will be a member from the judicial, like the judges of India, and there will be 4 members. As of now, this is defined as a constitution for the Data Protection Board of India. Might be, and yes, the central government have the power to, it will be independent body, but yes, central government will have the power to involve few persons in the Data Protection Board of India. And every member will be retained for a period of 3 years, and they have the chances of for one reappointment.
Ma'am, many of the participants asked for the PPT. It will be okay. We'll share the PPT after the seminar in NARC group. Okay. Then we'll share the PPT after the seminar in the NIRC WhatsApp group. Ma'am, due to the time constraint, I request you to take further as we have another half an hour for the seminar. So we will take rest of the queries after your second deliberation, ma'am. So please continue.
Great. Okay, so let's continue with the case study. So I have designed 7-8 case studies specifically for chartered accountants based on the provisions of this act. So first of all, what I'll do is I will read the relevant provision of the act on which the case study is based. So here the case study is based on the concerned part. Section 4, subsection 1 defines a person may process the personal data of a data principal only in accordance with the provision of this act and for a lawful purpose, for which the data principal has given her consent or for legitimate purpose. हम लोगों ने already पढ़ा that we have to either take a consent or we have to go for the legitimate uses for processing the data. Now how this is applicable or impact the CAs in practice. Let's say a CA firm, XYZ and Associates, manages database with client information and employee data. As per the DPDP Act, the firm XYZ Associate is a data fiduciary. So we are very clear here that the CA firm XYZ Associate is a data fiduciary because they are collecting the data from the data can be anything, but here we are talking about the personal data from various individuals and as well as the employee data. So what is the consent obligations say here? If once the act is implemented, then it is for the new clients. Let's say this act will be implemented, let's say today. So for all the new clients, we have to mandatory take the consent for data processing. Processing, I've already explained ki kya hota hai processing. So we have to necessarily take the consent. Then for the existing client, just before today, we already have a set of clients. अब उनकी consent का हमें क्या करना है? If the data retained legally because as an obligation, let's say I'm a chartered accountant and I am performing a statutory audit, and now it is my obligation to keep the data for a certain period. That is an obligation, and I didn't have a consent. Then in that case, the consent is mandatory. If I'm not retaining any data, let's say I have completed assignment, deleted the data, now I do not have the consent even for the client which is before the implementation, and now the consent is even not needed. Then optional retention. Let's say I have a data and it is not a legal obligation for me to retain the data, but I give the option to the data principal that either you take the data or I delete the data or I keep the data. If the subject asks me, data principal asks me to keep the data, then consent is required. And if they ask us to delete the data, then no consent of the data, no consent is required. Even if the act is saying कि previous, once the implementation take place, previous जो भी हमारे पास अगर consent already है तो हमें fresh consent लेने की जरूरत नहीं है. But as far as I know about the industry, the CA industry, we are not taking any physical consent from the data subjects or data principals. If you are already taking consent, then that's the best thing. if you are not taking consent and you mention that हम लोगों के पास verbal consent है, if someone is sharing the data, it means that हमारे पास तो already consent है. तो I disagree to this point, because honest to prove that कि हमारे पास consent थी to process the data lies on the data fiduciaries. So for that I request कि हमारे पास physical consent होनी चाहिए. कंसर्ट मैकेनिज्म सिंपल है, क्लियर कम्युनिकेशन, जो हमने पहले डिस्कस किया कि कंसर्ट में क्या क्या चीजें होनी चाहिए, क्लियर कम्युनिकेशन होना चाहिए एंड इजी विड्रॉल ऑप्शन होना चाहिए. अब हाउ और व्हाट स्टेप्स वी हैव टू टेक एज अ डेटा फिड्यूशियरी? Conduct a data audit, because ultimately to segregate the data, what is personal data, what is non-personal data, to which data this act relate, हमें वो करना बहुत जरूरी है, and this will be done only on the basis of the data audit. And once the data audit will be done, we can start taking the concern for the personal data, and we can start giving them privacy notice. So these are the basic steps that we have to do in regarding to the concern. Train the employees. This is the must thing, because as I've given other example also, organization can do their part on the higher level, and if the employees are not trained, a lot of breaches are going to happen and even nobody knows about, and ultimately the penalties will be leviable. So training the employee will also be a basic agenda to implement the act, and regularly review and update data protection policy. All other chartered accountants are well aware about how to do the review and update, so I think I am the one to comment over here. But yes, the policies needs to be continuously reviewed and updated. And yes, as we have discussed that if we are collecting the employment data, then in that particular case, this act is not applicable, particularly for employment data. For the employment purpose, then yes, this act is not applicable, and they are free to use the data for employment purpose of the employee. Then we have a case study 2 that talks about the security measures. So what is the relevant section? A data fiduciary shall protect personal data in its possession or under its control, include in respect of any processing undertaken by it or on behalf of data processor, by taking reasonable security safeguard to prevent the personal data breaches. So I have clearly explained that data fiduciary have an obligation to put security measures in place, and in fact they have the obligation to have a valid contract with the data processors. So how this will impact the CAs or the chartered accountants. ABC and associate manage their client logins, like login credentials for different portals, bank account logins sometimes, KYC documents sometimes, as well as the digital signatures. So what are the obligations we have? We have an obligation to put reasonable security measures. What will be the reasonable security measure? Depends upon case-to-case basis. For some organization, it can be an antivirus. For some organization, it can be a cookie management. For some organization, it can be putting up physical securities on the laptop, accessing securities, physical securities on the server. So that security measures are not defined in the act, because this act asks us to put on the reasonable security safeguards. So it depends upon the size or nature of the different organization work and size of the organization. But to give you a bit more clarity, if we are collecting the financial data, and if the financial data is directly relatable or identifiable of the person, let's say the bank statement, then we have to be cautious about keeping that data in our server, in our softwares, or in our laptops. If we are saving the phone numbers, email ID, ITR, bank statement, KYC, then the strict KYC security passwords needs to be put on the place, so that the information will not be used by someone who is not authorized to. Digital signatures. Digital signatures are already encrypted, so there is no security safeguard required to again secure the digital signature. But what I have seen at various places, that on the digital signature itself, we put on a slip to mention the passwords. So there is no use of that encryption because we are putting the password on the digital signature itself. So this means that we have to have a process in place wherein we can keep the digital signature encrypted. What are the security measures? We can use encryption, anonymization, de-identification, password management, access control. And yes, I've already mentioned that depend upon the size and the nature of the organization and case-to-case basis. What are the recommendations? Regular updating the softwares. This is a must thing that we have to regularly update the security softwares, antivirus is in place. Periodic security audits. If yes, the organization is too big, then we have to have periodic security audits to secure our database, to keep a backup of our database, and also the backups in some separate system, not in the same system where we have the server itself. Employee training on the security. Employee training is must for the implementation of this act. And yes, in case any breach happens, so first of all, we need to have a process in place where we can identify that a breach has happened, and also a process in place to recover, to put some control, to put some security in place, or to recover the data if some breaches happened. Then we have a case study 3 that talks about the privacy notice. Section 5.1 talks about every request made to data principal under section 6 for concerned shall be a complaint or preceded by a notice given by data fiduciary to the data principal, informing her the personal data and the purpose for which the same is proposed to be processed. So yes, we have discussed that we have to give a privacy notice along with the consent. So APJ and company, a chartered accounting firm, often require consent from the data principal for processing their personal data for various purposes. So what are the compliance requirements? We have to give a privacy notice, clearly mentioning the purpose, use of the data principals. The privacy notice should detail the personal data being processed and the purpose of processing. What about the new clients? Because we are taking the fresh concern for the new clients. So along with the concern, we have to mandatorily give the privacy notice. For the existing client, the flow will be same as well as along with the consent. Like if we are retaining the data under obligation or legally, like as a statutory auditor, then in that case, it is mandatory to give the privacy notice. If we are not retaining the data and we have completed the assignment, and so in that case, we are not supposed to give the fresh consent after the implementation. And likewise, we are not we do not have an obligation to give the privacy notice. If we have an optional retention, like we are keeping the data or deleting the data as an option of the client, then if we are keeping it, then we have to have a consent. If you're not keeping it, then the consent is not required. How we can give a consent? What are the easy measures to give the consent? Consent via email. We can take the consent via email and we can give the privacy notice along with the consent. We can put a privacy notice on the website if we have a general privacy notice, like a privacy policy. We can have a privacy notice on the website, and we can put a link in our email whenever we are asking for any consent. And if there is anything that is updation done to any of our privacy policy, we can send that through an email or a notification to our data principals. Then valid contract. This is also very important. Section 8, subsection 2, a data fiduciary may engage, appoint, use, or otherwise involve a data processor to process personal data on its behalf for activity related to offering of goods or services to data principals only under a valid contract. So background, M&O and company or CA firm frequently engage third-party service providers for work outsourcing and share client data with associated partners for processing assignments. What is the compliance requirement? M&O company act as a data fiduciary when sharing data with the third parties. Data processor must adhere to data fiduciary obligation if they determine the purpose and means of processing. So it means that कि अगर हमारा डेटा प्रोसेसर सारी चीजें, सारी ऑब्लिगेशन वही कंप्लीट करता है जो हम उसे कंप्लीट करने के लिए कहते हैं, देन द डेटा प्रोसेसर डू नॉट हैव एनी ऑब्लिगेशन. बट if the data processor itself process the data and define the means of processing the data, in that case data processor will become a data fiduciary and all the obligation of data fiduciary will be applicable to data processor. What are the recommendations to comply with this obligation? First of all, we need to have a valid contract. If we already have a valid contract, then that's great. We can put and check whether we have a privacy related regulation, privacy related clauses in it. If we do not have, we can revise or send an amendment to the contract. Then we clarify the processor's roles. Yes, we have to clearly clarify the roles and give them a clear instruction in the contract itself, the purpose for which we have obtained the consent, so that the data processor will process the data only on that for that purposes. Then conduct audit. Yes, it is recommendatory, not mentioned anywhere in that, but yes, we can have this in a contract that we conduct regular audit for the processors for compliance to understand their security safeguard, their operational measures, and also to check if any breach happened during a period of time. Review contract, yes, as soon as our concerns or our mechanism as a data fiduciary is updated, we also have to review the contract and reflect changes regulation in the contract with the data processors as well. Then we have a case study on the data retention part. Section 8(7), a data fiduciary shall, unless retention is necessary for compliance with any law for the timing in force, erase personal data upon the data principal withdrawing her consent, or as soon as it is reasonable to assume that specified purpose is no longer being served, whichever is earlier, or cause its data processor to erase any personal data that was made available by data fiduciary for processing to such data processor. So here, AAA and company, a CA firm, retains client data either under statutory obligation or for a discriminatory purposes. So what are the compliance obligation AAA and company had? As a bank auditor, what are the law obligation? As a statutory auditor of a bank, they have the obligation to retain the data for a certain period of time. But if they are retaining the data for a certain period of time, then they have to ensure the reasonable security. If the data is non-obligatory data, delete upon the withdrawal of consent or once the purpose is completed. Data processor deletion obligation, yes. Once we receive the withdrawal of consent from the data principal or our purpose is completed, we have the obligation to get the data deleted from all the data processors. So what are the recommendations? Ensure statutory data retention. We have to focus on the one concept of data minimization, because once we follow the concept of data minimization, like keeping the data that is necessary or mandatory, all the problems of data retention will be resolved. Also to categorizing the data between personal and non-personal data. So yes, we have an obligation of legal compliance, erasing statutory data retention compliance with laws and secure storage. Then secure retention, that we have to keep the data secure. Timely deletion, that we have to delete the data on timely basis. And data processor compliance, that it is our obligation as a data fiduciary to get the data deleted from the data processor. So this is basically the case study about the data retention. And now here, let me give you a idea about how the data retention will play a role, because once we'll start deleting the irrelevant data, so automatically the compliance will starting in place, because ultimately data minimization is one of the pillar of this regulation. Then there is a other case study talking about the infrastructure of this infrastructure of the CA forms or organizations. Data management infrastructure in a CA office. What are the issues that we have identified? Data minimization. We always take excessive or unstructured data. Whenever we have to take a client from data from the client, we ask as many as information because we just don't think of which information is required. We ask them the client to send all the details. Then we have the shared storage. Yes, we use sensitive data on our platforms like Zoom, Anydex, and Computex, and such other platforms as well. Then we have a third-party softwares, use of softwares like PDF conversions, like online softwares we use for PDF conversion. Then insecure communications like sensitive data shared over WhatsApp, Telegram, and other insecure channels. Then personal device usage, yes, work conducted potentially on a personal devices which are not as secure as office devices. So these are the issues that were identified. Then additional issues are there is a no privacy policy exists or a lack of privacy policy, and even if the privacy policy exists, there is a lack in implementation. Then digital signature, yes, I've already discussed that even though digital signatures are encrypted, but they are stored in such a way that the encryption fails in itself. What are the recommendations? Data minimization culture, that is a must thing. Secure software, adopt secured paid softwares. Third-party agreements, to have a third-party agreements in place. Like if we are using the Zoom, Anydesk, Competence, we need to have a habit of reading their agreements, like how the data privacy kept as private by these kind of softwares. Then device security, implement encryptions and security measures on personal device, and secure communication, prohibit insecure channels for official communications. Then yes, this is, I think, the last case study about like if a person is chartered accountant is in the place or working as an internal auditor, then in that case, what is the compliance requirement on a behalf of a chartered accountant who is working as an internal auditor? Then they have to process the data, whatever position they are working as an internal auditor, to what are the processing purpose. So I have taken an example for John, a chartered accountant, work as an internal auditor. He regularly assess sensitive financial and obligation data to ensure compliance and mitigate risk. What are the compliance requirements? John must process data lawfully and legitimate auditing purpose. Data security, he have to implement the data security because in our position of internal auditor, he have to put security measures because he is basically a data fiduciary as well as an internal auditor. He has the obligation to conduct the risk-based audit and put security measures. He have to put a concerned management in place and data retention. How he work as an internal auditor? If he working as an internal auditor, he must be doing the audits on a risk-based approach, considering the risk matrix. So in that, considering the risk matrix, what he has to do is basically considering data protection is also a risk, and conduct a periodic audit in the organization. As he's doing as an internal auditor, he has to conduct the regular audit for the data protection or private personal data as well. So we can say that he has to conduct the audit planning based on the risk-based metric and prioritizing the data privacy.
Hello. Ma'am, there is some voice internet issue from your side.
So kindly wait for a moment. I think Divya, maybe your internet problem was there.
Yeah, I'm here.
Yeah,
Yeah,
yes,
please,
ma'am. Yes, ma'am.
please
Continue,
start.
please.
Yeah, so sorry for the inconvenience. I'm just sharing my screen again.
So this is the area where we were talking, protection, data protection, internet, ये सब चीजें, totally IT based.
Yeah. Yeah, exactly. So I think it just got disconnected at the point of cookie concern. So let me continue from there as well. So yeah, I was discussing about the cookie concern. So whenever we are using or collecting the data from our website, we have to take the cookie concern. Cookies are basically, I think everybody have an idea, like cookie are basically the personal information collected automatically when we are browsing the website. So we have to take the concern. So for what purpose we can use your data collected automatically as cookies. So let me show you a website of a firm wherein I can demonstrate that how this basically works. So if I'll just open a website of KPMG India, we can see that they are taking our concern. They are asking for my concern. Like if I click on the manage cookies, so they are asking me to give the specific concern for basic, like how they can either they can use the my cookies for targeting cookies, for performance cookies, for functional cookies, and these are strictly necessary cookies. So basically, these kind of consent is required. If I'll do the accept all cookies, it means I'm giving them a permission to use my cookies for targeting marketing, for performance marketing, for functional marketing. And if I like deselect all of this, that means I'm not giving them the permission to use my personal information and use my cookies. So I think every CA firm must be having their website and they must be collecting the data. So I think cookie management is also to be considered if you are collecting the data from the different websites. So I think this comes to an end, and now I'm available for the queries.
Thank you, Divya ma'am. As I have one query, ma'am, as the DPDP Act suggests, like now data fiduciary will not able to track the activities of the children on social media, and they can't show them advertisement on the basis of these tracking activities. So it is very hard to digest for me. Like many big players in the market are running their shop on the basis of this tracking and showing advertisements. So all these activities are going to shut down, or after this act, there will be some checks and compliance only, though which they need to follow only.
So as far as Act is concerned, Act is not giving any exemptions regarding to the children's data, because children's data, their Act is giving very importance or significant importance to the children's data. So अभी जो clear mandate है वो यही है कि हम children data को monitoring, target monitoring या target behavior के लिए use नहीं करेंगे. But yes, as I've mentioned during the presentation as well, the central government have the option that if the player, let's say any player, is keeping the data safe and secure and central government can ascertain it, then they can lower the age for the parental consent as well as for the target monitoring and the other purposes. But otherwise, children's data considered to be a very of a specific importance, because as we are a growing population in India, and children's data considered to be very of significant importance. So as I'm not committing here that ये सारी जो भी industries हैं वो बंद हो जाएंगी, because as far as GDPR is also in GDPR, these players are already performing very well. So they'll just not following these in India. But yes, if we talk about Europe and America, they're already complying with these regulations. So once the regulation will be implemented in India, they have to comply here as well.
Sanjeev ji is asking, ma'am, what are the specific professional opportunities for CAs after this act?
Yes. while I was explaining the significant data fiduciary slide, I want to explain about the opportunities as well. But as our chairman has already mentioned that they can have a separate session for that. But yes, to give you a brief about the opportunities, as I've mentioned that we every significant data fiduciary have to appoint a DPO, data protection officer. So this is a very important, I think, important opportunity for us. Being a chartered accountant, we can perform our work as a data protection officer as well as virtual data, and as a independent auditor, that significant data fiduciaries has to appoint an independent auditor also. So in that point also, chartered accountant can seek certain opportunities. As far as the consulting part of this act is concerned, we are doing various consultant assignments, so we can do because we are somewhere working as an internal auditor also for various of our clients. So we can also include this as a consulting assignment or internal auditing assignment.
Can Samanta ji is asking, can only chartered accountants will only be able to act as DPO?
No. Anybody have the specific knowledge about the data protection regulation across the globe can act as a data protection officer.
Now I think we have done with the query. So I would say, ma'am, it was a wonderful deliberation from your side. And I hope that all the participants will be feel same as me, that before this seminar, we were having the knowledge about this act has now substantially increased after your deliberation. So thank you so much. So we have Jagjit sir with us. Jagjit ji, are you there? So we have Jagjit sir, Nikasa chairman. So I would request Jagjit sir to say his closing remarks. Jagjit sir, please.
Thank you, Akashi. I would say, after listening Divya ji, because she has mentioned each and every item that is related, which is related to this data protection. So many questions, a general question asked by Akash ji, and of course Mahesh ji at the starting, initial stage when Mahesh ji has asked, and the respected member, they have asked so many questions. But because Divya ji, this is a very new area, so still we have to find out some other problems which definitely in the future we will face in this matter, because this data is a very, I would say, very sensitive information. Sometimes we have seen in the case of like the multinational companies, when the employees actually working in those companies, so there is a leakage of data. The big companies always lose type of face these type of issues, and facing so many the data loss issues in the company, because the information, the data is very important for these type of company, whether they are supplying information, they are working on information, they are actually data analysis company, those are actually playing with the data. So these type of companies always having the input, that is the basic raw material for those companies' nature of business. So it's a very big area, I would say. And being a professional person, yes, I'm expecting in the coming years, maybe after 5 years, maybe after 10 years, definitely we will see, and we have so many opportunities. So we have to focus on the particular area, that is data protection area, if we want to work as a practicing professional in this particular area. So we have to decide these type of things, because as a practicing chartered accountant, I would say we are managing with the digital signature as mentioned by Mahesh ji and the initial stage. So that digital signature is a very sensitive master key, so that can create anything. The company owner may be Akash ji, but after using that DSC, maybe the next owner will become Mahesh ji. So these type of information, I would say, where electronic informations are there, the data is actually through the electronic system moving from one side to another, and in between that transformation of the information, we need the protection, we need the control, we need the security. So that is why this Act 2023 Data Protection Act is very, very important. And you have mentioned so many important, so many relevant things. So definitely the members present in this webinar have, got more information from your side. So on behalf of, yes, of course, Akashji, you will conclude this session and you will present the memento of this webinar, na?
Ma'am, you can, sir. Please, please.
Okay. So should I conclude this webinar?
Yes, sir. Yes, sir. Just we can give some
Please, please.
2 minutes to Maheshji also for conclusion. of all of
Definitely. I'm just handing over to the Maheshji. So, I was just talking about this, these type of controls related to the sensitivity of the data, related to the protection of the data, related to the controlling of these type of data. Very, very important. So we have heard so many times, so how to protect this database management system. So we have to, because that is the major input for the companies. Those are actually playing with the data. So that is the input, Akaji, from my side. So before concluding, please, over to you, Maheshji.
Thank you, Jagjit sir. Thank you so much. Now I would request Maheshji, our program coordinator, to say a few words about the for the seminar. Maheshji. Sir, I think you are on the mute, Maheshji. Still, you are on the mute, Maheshji. Please unmute yourself. I think there is some technical issue on the Maheshji's side. So, ma'am, on behalf of all the participants, I would like to thank you for such a deliberation, and I would like to thank to NIRC team for organizing such a tech session on the very hot topic on the DPDP Act. So I would request Jagjit sir. Sir, will you present the certification as we do at the end of the webinar? Is it ready, sir?
Yeah, the certificate is ready with me, and just I have to check if I'm the host, then I can. Otherwise, I would say again, it's a need the protection. So I'm not the host, so I cannot. But yes, Divya ji, you are the only host. If you can, if you can create me as a host, so that I can present that memento.
Sanjeev ji, are you available, sir?
Sanjeev ji is not here.
Sanjeev ji, the host, sir. I think.
Sanjeev ji is not here. Divya ji, can you create me, or can you authorize me as a host? Divya ji?
Actually, I'm trying, but I'm not
Because
able
you are
to
the host
because
now. Without becoming host, I cannot represent the memento, the token of love from NIRC.
I think you are able to.
Just a second,
Yeah,
I'm
can
cross-check. Yes.
Right?
Is it available?
Yes, sir. Yes, sir. Is it available?
Yeah, this certificate is basically, the certificate of appreciation for CA Divya Jain ji for you. And, the efforts which you have given in this webinar, of course, remarkable efforts you have given. Very important area you have discussed. So many things. So thank you for your contribution in this profession, for the benefit of members, for the profession benefit as well. So thank you for your appearance, your availability, your precious time, your important information from your experience, which you have shared with us. So thank you, Divya ji. So the next certificate for just a second, I have to because I'm not able to move. Yes, Maheshji, for your presence in this webinar. The Maheshji, very young champ, I would say the chairman of Sangrur branch. So Maheshji, for your contribution, this is for you. And of course, now the last but not the least, my younger brother, Akash Vashishji, for being a moderator of this program. So this certificate next one is for you. I'm not able to move for the next one. Yes, this is for you. This is for you for your wonderful, I would say, contribution in this webinar to making this webinar a successful webinar for the benefit of members. So on behalf of NIRC, on behalf of the whole team, So thank you, everyone. And thank you, present member in this webinar. Yes.
Thank you,
Want to say
Jagjit sir.
something, Divya? Huh.
Thank
You're
you,
welcome,
Jagjit.
sir.
Thank you, Jagjit sir. Thank you, Divya ma'am. Thanks to whole NIRC team for organizing. I think now we shall conclude, sir.
Yeah.
So thanks for
Thank
all
you.
the participants. Thanks for participation.
Thank you, everyone.